All right. So good morning, everybody. Happy Wednesday. It was good to reminisce before we officially started the program about what life was like before computers. But here's the one thing that probably didn't change is HR matters, right? I mean, you think about, obviously during COVID, it definitely, and again, I told our HR professionals that they probably had the hardest jobs just kind of managing remote workforces and vaccines and spacing and all the other things that went into the pandemic. But to me, it hits all of our sectors. It really doesn't matter if you're a bank or a manufacturer or a law firm. I mean, HR issues are important. And that's why today we have three great speakers. And I'm also going to jump in and talk about some of the things that are going on in Trenton that impacts HR. But I first want to thank our sponsor, George Tyler, and his colleagues at TAC, which is Tyler, Avasano, and Krantz, for sponsoring today. Because again, you've heard this before, we're proud of the fact that we keep our virtual events free to members, and it's through the generosity of our sponsors. So thank you, George, on that.
My pleasure, Tony.
So, let me introduce real quickly the three speakers, and I'll start with Alex Rubin, who again has presented before this group, the HR Forum. She founded Rubin Employment Law in 2010. She actually was a journalist before becoming an attorney. She helps a lot of employers with these types of issues that we're going to talk about today. So Alex, thank you for being here.
Thank you.
We also have Fred Amaguchi, who's the Vice President of Sales and Marketing for Data Screening and the founder of Selfie Background Check. And if you don't know Fred, you definitely want to know Fred, because he could definitely dig up some things on you in terms of background checks. So I know, right. Fred, I'm always going to smile whenever I see you, Fred. So thanks for being here.
Thank you.
And then finally, and I had the pleasure of meeting Jose Jara a couple of weeks ago, but he's an attorney at Fox Rothschild. And you know what, Jose, looking at your bio, all about ERISA, right, which is the Employee Retirement Income Security Act. So Jose is going to cover the Secure Act 2.0, I guess they call it. And we could talk about some of the issues with, for example, employee manuals. Alex is going to cover the non-competes and New Jersey WARN Act. Fred's going to talk about the latest on background checks and what you have to do when you run a background check. So with that, I figure let me start with Alex. And really, I guess the most pressing thing right now for a lot of you is, and a lot of people may not know about the New Jersey WARN Act, Alex. So if you want to just kind of kick off with that and just explain what it is. Thank you.
Sure. So there's been a New Jersey WARN Act for a long time. I won't bore you with the official title of it. People just call it New Jersey WARN, New Jersey, the mini WARN, because there is a federal WARN Act. And it used to be that it pretty much, there were a couple of slight differences, slight nuances, but it pretty much mirrored the federal WARN Act, which meant you had to give 60 days notice if you were laying off, having a mass layoff or closing a business, right? And it used to be you needed to have at least to be covered by the act. In New Jersey, at least, you have to have at least 100 employees and be laying off at least 50. The amendments to the WARN Act, which were actually passed back in, I think it was 2020, right, Tony? It was either right before or during the pandemic, and then they were put on hold. The implementation of them was put on hold because of the pandemic, and now that's all gone. April 10th is the day when the new amendments go into effect. It's now 90 days notice employers have to give, and it's 50 employees could be working anywhere in the state of New Jersey, not restricted like within a geographic region like it used to be before. And they could be full-time or part-time employees. It doesn't matter. So that's broadened. The reach has broadened, but it's also 90 days notice, which, by the way, New York's had that requirement of 90 days notice for quite a while. But in addition to that, which New York doesn't have, is employers now have to pay every employee one week of severance for every year of service. Every employee they lay off, under the New Jersey WARN Act, now under the amendment. So that's starting April 10th. That's a huge difference. And if you don't comply, you have to tack on an additional 4 weeks of severance. So that's really it in a nutshell on that. But that's something that's, April 10th will be here before we know it.
Yeah, we already have a question. And just before we get to Gail's question, and again, Gail runs the New Jersey Landscape Contractors Association. Just to kind of just give you guys some background, this all started with, at least in New Jersey, right, Alex, was the Toys R Us shutting down. And I think WARN stands for
Yes.
Worker Adjustment Retraining and Notification Act. So when
Correct.
Toys R Us went bankrupt and it made the news, I know Senator Cryan was one to jump on, the fact that we needed some sort of notification of these employees so that it's just not out of a job the next day. I think what's important here is what Alex was saying about the severance pay, but also if you read the law, right, Alex, I think it's 50 employees or more is considered a mass layoff. So I've already
Yes,
got
correct.
questions from members that maybe have 400 or 500, and they said, well, if we lay off 25 people at a time, or do we get out of the WARN Act? And again, I'm not an attorney, so I think you just got to be careful there.
Yeah, I
you
think
know,
it's over. I mean, I think it depends on the time period. I think if you space it out long enough, and I don't recall what that time period is, I believe it was 30 days. So if you do, right, 25 now and 25 in another 30 days, but I'm not 100% sure about that. I'd have to look at the statute to
So
confirm that.
I guess Gail has a good question. Since landscapers are seasonal, does that impact seasonal workers?
Yes, it does. Doesn't matter. Full-time, part-time, doesn't matter. All employees it impacts. So,
Yeah, and
again, if you're only laying them off temporarily, then, maybe not. Again, these are like nuances that I'd have to look into.
yeah. And again, I think what people don't, hopefully people are starting to appreciate it. I know Julia, we sent it out in Business Beat maybe about a month ago with the act itself. We could always resend it. But hopefully everybody knows that April 10th is right around the corner. So just
Yeah.
kind of keep that in mind if you face the unfortunate circumstance of having to lay people off. And again, Alex, talking to some of our other attorneys, they're saying that New Jersey is kind of unique with the 1-year severance pay.
It
Which-
is. It really is. Well, it's not 1 year. It's 1 week for every year of
I'm sorry.
service. So let's say an employee's been with you for 5 years, you got to give them 5 weeks. They've been with you 10 years, it's 10 weeks, et cetera. Now, look, when you're laying people off, severance is always a good idea, but this makes it mandatory. You don't have a choice here. So it's not even like you can have the employees sign a release necessarily. I'm not, that's something I'd have to look into. Like, can you still, because typically an employee would sign a release of any claims if they're getting something more than, they need to get something more than what they're already entitled to. So if they're already entitled to, let's say it's a 5-year employee, so they're already entitled to 5 weeks. So if you give them 6 weeks, you can get them to sign a release, right? But that's the rub there.
So maybe this is a good segue into non-competes and what's going on there. But let me ask a general question for the attorneys and Fred, if you want to jump in. But I've been told that, you got to be careful with offer letters nowadays because people could perceive that as a contract. Anybody want to weigh in on, is an offer letter a contract? And are we still in at-will state?
We are still in at-will state. And it really depends what your offer letters should always say this, this is at-will employment, right? Unless it is for a particular term, unless it's a 1-year contract. And an offer letter, yes, it is a contract. It's an agreement, right? If both parties sign it, it's an agreement between two parties, the employer to employ the person, the employee to work there for a certain wage, et cetera, benefits, whatever's in the offer letter. It's like it is an employment agreement. It's just not as formal.
Right.
But you put in there, I always advise my employer clients to put in the offer letter that this is, your employment's at will. We can terminate you at any time for any reason, with or without notice.
Yeah. So any questions on the WARN Act? I'm sorry, Jose, were you going to say something? I'm sorry.
No, I was just going to add to that. Just be careful the way you craft your offer letter, because just because you put this is an at-will employee, in substance, it may be viewed as a contract. If you have a certain term limit that you're promising the employee to stay, it can be viewed as a contract. But nonetheless, you can caveat that in the handbook as well, reiterate that you're an employee at will.
Yeah. Totally agree.
All right, any questions about the WARN Act? Okay, let's go to non-competes. Alex, you want to kick it off?
Yeah, so there's nothing is firm yet on non-competes. I'll start with the new. There was a lot of stuff written in back in January about the FTC proposed rule on non-competes. There's also a proposed federal law, and there's a proposed New Jersey law restricting non-competes. So the FTC rule is pretty broad. It's proposed. It's in the rulemaking process. It's in the comment period. And they're actually asking for comments about specific things. But what the proposed rule would basically ban non-competes across the country as declaring them as unfair competition. And the only exceptions would be perhaps, regarding the sale, if it's in conjunction with the sale of a business. There's been a lot of questions about, and they do want people to comment about, well, what about executives, right? What about, higher earning employees? Should there be a distinction between low wage and high wage employees? Whereas, for example, a non-compete would apply to a higher wage employee, but not a lower wage employee, which makes sense anyway. What about franchisees? What about, negotiate agreements, stock incentives, et cetera? And then what about, there's this doctrine called the inevitable disclosure, right? Where, you're working for a company for a long time, their secret sauce, and it. It's not like you're not stealing their confidential information. You're not taking documents with you, but you have this, the sauce, the secret sauce, whatever it might be, in your head. And you go and work for a competitor and take that with you and use it there. I mean, that's the reason to have a non-compete as an employer, right? To prevent employees who have that knowledge from using it to unfairly compete against you. So I think the FTC is very one-sided, very employee friendly here. I'm not adverse to that, but I represent employees and employers. So it is a big issue. How to prevent unfair competition, from the employer's perspective.
So one thing, Alex, on that, on the FTC rule, we're going to submit comments at
Great.
CIANJ. The comment period just extended to April 19th, about a month ago on this. I want to say it goes retroactive, so don't think, doesn't apply to any agreements in place. I mean, that's how significant it is. And he was convinced that people will probably adjudicate the rule once it goes final if they don't. Can people hear me, or am I frozen?
You're kind of breaking up a bit, Tony. And I was wondering if it was
You're frozen now. Yeah.
Oh, sorry. I don't know. Yeah, I'm still breaking up. Hopefully, can everybody hear me?
I can
Yes.
hear you.
Yeah, we can hear
Anyway,
you now.
Yeah, with the non-competes, Alex, I just wanted to mention that the comment period was extended to April 19th.
Oh, that's good. That's good. Yeah, I think there are going to be a lot of comments about it. And if it does go through, I think there are going to be some court challenges to it as well. There's also, the New Jersey proposed law, which I understand hasn't really gone anywhere. That's not quite as onerous, but it also has a severance component to it, just like just like the WARN Act, where if you're going to, you can't restrict someone for more than a year, more than 12 months, and you have to pay them for whatever the time period of the restriction is. That's under the New Jersey proposed law, and it also wouldn't apply to. I think you can only have a non-compete for an exempt employee. You can't have a non-compete at all for a non-exempt employee or an independent contractor, which again, it's probably not a good idea anyway. But understand under either scenario, employers still have tools in their arsenal for, to help prevent employees from stealing their trade secrets and confidential information. You have confidentiality agreements, you have non-solicitation and non-solicitation agreements. So you still can prevent employees from stealing your customers, as long as it doesn't unduly restrict them from working in the industry.
Right. And I'm glad that you mentioned the non-solicitation, because there are different, I guess, varying restrictive covenants, and this was more or less on the right to work, right, is the other side of it. They're saying that these non-competes really restrict folks' right to work.
Yeah.
So
here's also a key difference between the proposed FTC rule and the proposed New Jersey law, and that is the proposed FTC rule would rescind any existing non-competes, whereas the New Jersey law, at least in its current form, would not be retroactive.
Correct.
So that's a big change. There's also kicking around I think it was reintroduced in January, a federal law as well to restrict non-competes, and it's somewhere pretty much, look that one up, the Workforce Mobility Act. Again, it would codify, that the statement that non-competes, or law that says that non-competes are unfair competition, unfair trade practice, actually, and it would effectively, again, there would only be limited exceptions. Dissolution of a company, for example, sale of a business, it allows for public and private action as well. So again,
I guess the advice, Alex, if to the companies is, if you're going to enter into a non-compete, non-solicitation, I guess I learned from the banking community that they do something called garden leaves, right? Where, before you start with another bank. I don't know if you want to maybe opine on what a garden leave is. And
yeah, I mean, that's basically what the proposed New Jersey law puts, makes it mandatory that you have to pay, for the period of the non-compete. When I'm negotiating on behalf of employees, I often negotiate for that. Like, look, if you're going to restrict them from working in what they know in the industry, then at least pay them for that period of time. Often that's a good negotiating tactic where you can, either reduce, maybe they don't want to pay them for a year. So they'll say, well, okay, we'll reduce the non-compete to 6 months or 3 months, and then we'll pay them for that, give them severance for that period of time. It is very common in like you said, Tony, in the banking industry, typically, and even if, 3 months, you just get 3 months, they call it garden leave. We're paying you to work in your garden, not to work in the banking industry. So,
yeah. And so I also am kind of intrigued, because I've talked to some members that think that the courts won't uphold these non-competes, but I could tell you 2 of our members happen to be in the environmental community, sued each other over non-competes, and the one company that had it won. So so they are enforceable. So
they are. They are currently. They are, at least in New Jersey. They are not so much in California, but I don't practice there. But it just what I hear.
Any questions on non-competes? All right, Alex, anything else you were going to cover before we go to Fred? Or
I did just want to raise the issue of severance agreements, because the National Labor Relations Board just came out with a decision that says that confidentiality and non-disparagement clauses in severance agreements are unlawful, that they impede an employee's right to collectively bargain, and right to engage in concerted collective action to improve their working conditions. That's a National Labor Relations Board, which a lot of people think that it only applies to unionized workplaces. Well, that's not really true. That can also apply to non-union workplaces, but it would only apply to non-supervisory employees. So you probably could enforce confidentiality and non-disparagement, agreements for supervisory employees, but at least, it could be challenged before the National Labor Relations Board.
Interesting.
So
Thank you, Alex.
We'll see if that might get appealed to the courts.
Yeah.
Just to add to that, they spoke at the American Bar Association a couple of weeks ago, and they basically said they would aggressively enforce this case that they have. So any confidentiality agreements, so you're basically, so it applies to union and non-union. So it's basically employees talking about the terms and conditions of the employment. So anything relating to that, that if you try to snip it, it's going to be a problem. And so I caution folks as well, aside from the severance agreements, that if you have confidentiality policies, to review that within your employee handbook.
Yeah, good point. Yeah.
Okay. All right.
The other thing about that is, thinking about in terms of severance agreements, well, these are soon to be, if not already, former employees. Why is it, true for them? And the NLRB said, no, it doesn't matter that they're former employees. They could still, go and sue their employer or be part of an investigation into unfair labor practices. So they shouldn't be restricted from discussing these issues.
All right, thanks, Jose. Thanks, Alex. Fred, let's talk about background checks, because I know a lot of our companies probably use you and your service. But what should people know about background checks and what's changed?
I think that one of the big things is basically what you should be doing before and after the background check is done. So the big thing now is ban the box. When you think about that term, it literally means the little box that companies used to have, where it would say, please check off if you've ever been convicted of a felony or a misdemeanor. In approximately half of the states, there's been an action called ban the box, which literally means you can't do that anymore. So in New Jersey, you cannot advertise, you cannot mention or have questions or statements about background checks pertaining to your employment with your company. You cannot say anything of that. And the idea behind this was basically to give people who have been convicted of a crime a second chance, so that, if you advertise, we don't hire criminals or anything like that, they're not even going to attempt to see if you would employ them. So they want to basically, give people a second chance, integrate them more into the public and in employment. So in New Jersey, part of that, besides you can't ask anyone, you can't inquire or ask them about the background check or tell them about the background check until the first initial interview. So that would mean, let's say, a phone call, any type of walk-in or anything like that. Now, on the other hand, New York is a little bit more stringent on their laws. And in New York, of course, we're so close to New York, you actually cannot mention background checks until a formal offer of employment has been made. So, the differences with the states is pretty high. General rule of concept, which we advise all of our clients and most attorneys will say, is to be safe, because a lot of companies have different locations and the rules change state by state. So a general idea or best practice is just do the background check or mention the background check when you make the formal offer of employment. I would say that's the biggest thing. If you look up litigation with background checks, it mainly has to do with this portion of when you're doing the background check, and as well as the forms that you have to give the people before you do the background check as well. So to kind of take it step by step, formal offer of employment, tell them it's contingent upon a background check. Now, when you do the background check, there's forms that you have to give. Of course, you need written authorization, but even those forms are highly sensitive in what you contain and do not contain. All the forms have to be their own documents. You need two types of disclosures. You need the guidelines, the summary of FCRA rights, and then of course you need an authorization. Those four forms have to be separated. They can't be involved in an application, and they can't be all together as well. You want to make sure you're doing that.
So can you, thank you, Fred. Can you talk about, because there's actually a bill in Trenton where unless your job is going to deal with money, you really can't run a credit background check on employees. I mean, I don't know what the policy is today.
New York. The general policy, credit checks have been an up-and-coming topic in background checks because we actually have a lot of banks as clients, and it's ironic because I would say half the banks don't even want to touch it. They don't do credit checks. And then the other half of the banks, the first thing they do is credit checks, and the person has to pass the credit check before they do the criminal portion of the background check. So you have two different sides to it. But in New York, they're more stringent upon you have to, the job has to be a direct correlation to you being, for you to do credit checks. So it has to be someone who's handling highly sensitive information, personal information of people, or someone who's involved in money, direct involvement. And if it goes to litigation, you have to be able to prove that it has a direct correlation with the job. And as we always say, and another tip here before you even start doing background checks is have a policy in writing on what you're willing to hire for and not willing to hire for. And that policy, the FCRA states that should be dependent upon how long ago a conviction has taken place on a person, the direct correlation to the job that they'll be performing, as well as the severity of the crime. So I always use this example. So if say you're hiring a janitor who's going to be cleaning your office, in the middle of the night while no one's around, and it comes up that they had a drug conviction or maybe violence. And, when you look at your guidelines on what you're hiring for that position as a janitor, it's not really going to make that much of a difference because he's not going to be around other people. Now, on the other hand, if you're hiring a CFO and that same conviction came up, now, that's a little different story because now you're questioning that person's decision-making abilities, maybe not just because they're handling certain things, but that may have been a poor decision on their part and you don't want them running your company. So that's really what's going on with the credit checks. Not many people are doing them because of that. And, when you think about it, if a person has bad credit, I mean, it may be a number of different things. Maybe they had an accident going through a divorce, which actually leads into the end of the background check. So let's say you do a background check and there's a conviction on there. There is a process that every company and every employer has to follow. So again, pertaining to the Second Chance Act, you have to first give them what's called a pre-adverse letter. And that letter basically states, hey, we may or may not make an employment decision on you based upon your background check. Here is a copy of the background check. You also have to supply them with the Fair Credit Reporting Act, summary of your rights. And the process is basically so that that person can either come back to you with an explanation of, what may have happened. So in terms of like the credit, for example, if you deny employment because a person has poor credit, that person is given the chance to come to you and say, hey, look, I've been down on my luck this year. I had a bad car accident. I have medical bills. I had a divorce. Okay, that may be acceptable. Whereas another person comes to you and says, I'm going to probably claim bankruptcy in a couple of years. It doesn't really matter. I don't really care about my credit. Okay, so that person you're probably going to disqualify. But the point is you want to take an individualized assessment when you're looking at any type of convictions that come up on the background check. Now, if that person is also given the opportunity to dispute with the background check company of the results of the background check. So those two things are the reason why you send a pre-adverse action letter. Now, you're supposed to wait at least 5 days for a person to respond. And if that does not take place, then you send out what's called an adverse action letter. Similar letter, except it states that we are either rescinding our offer of employment or terminating your employment at this time. Go ahead, Tom.
I guess let me ask you, so the candidate has a right to if a background check was run, do they have a right to see that regardless of whether or not they're going to get offered the job?
Absolutely. And your background check company or you, when the person is doing filling out the preliminary forms, it must state that they're entitled to a copy of their background check. So no matter if they fail or pass the background check, they still have that option, and it should be given to them within that paperwork that you first give them.
Interesting. Okay.
Not many people know that, a lot of,
Yeah.
and that's one of the reasons we started the selfie background check, to give people more knowledge about what their rights are with these background checks. Because a lot of people don't know that you could, when a company does a background check on you, you could ask for that. They also aren't aware that, the rights before and after the background check to an individual.
So maybe a good segue into your selfie background thing, because I've heard your speech on it. I think it's important. So when a company runs a background check, does it include social media?
Great question. That's a kind of a gray area now, controversial, because, is it someone's own words? Is it, personal? You shouldn't be looking at that. So a lot of companies, whether they're doing it officially or non-officially, I think the latest stat was about 70% of all companies are looking at candidates' social media. Now, as a background check vendor, we always advise, and most attorneys I've spoken to advise, that you should use a third-party company if you are doing that as an HR professional or as a company. It obviously takes the bias out of it. We have a product that is driven by AI, so it takes 11 risk characteristics. So that way it takes it out of the hands of a person, because when you're looking at social media, there may be some pictures or some posts that may influence your decision to hire this person that you really shouldn't. So we always advise using a third-party company to do that. On one hand, you have people say, well, that's my opinion. I should be able to voice my opinion however I want. That's true, and I agree with that. But there's also a reputation of that person that comes attached to it. And as everyone sees in the news, I think the more of the examples are when there's people who are already employed, they post something that they shouldn't have posted, and then the company ends up firing them. So it's almost like companies and employers are being proactive with this. Let's check out this person's reputation online. If they're comfortable putting something out there for the world to see, well, then a company that's hiring them should be able to look and see what they're putting out there.
Right. All good stuff, Fred. Any questions about background checks?
Tony, I have a question for Fred. One, does the second chance law apply to all companies of any size, or is it limited to large employers? As the WARN Act has a cutoff, I think, isn't it?
50, yeah, 50.
50, yeah.
50.
Certain laws specific, I think it's 50 or more employees, but everything that I mentioned, it doesn't matter how big or small of a company you are.
Okay.
And yeah.
And so again, we could always revisit some of these issues at the end of the program. But let's go to Jose, who again, from an ERISA perspective, I guess the big news is the 401ks Secure Act. Jose, welcome. The floor is yours. Thank you, Fred. Thank you.
Thank you.
Just to add to a point on social media and a plug-in again for a handbook, you should review your handbook for your social media policy, because you'll be surprised as to what people post on their social media. It may be considered some form of bullying that can be transformed to harassment if it's relating to somebody's, race or disability or things like that. That people are not aware that, oh, well, yeah, it applies to your social media post that you post in your own home, right? So people are not aware about that, and especially with people working remotely, how do you monitor that? Well, if you have a employee handbook that lays it all out, everybody understands what the rules are up front.
So Jose, do you want to talk about employee matters? Because one of the things when Jose and I were kind of briefing with Alex and Fred, again, and talking to a lot of members, I was surprised that some members still do not have an employee manual.
Yeah.
And so I guess the verdict out there is dependent on who's counseling you. It could be good or bad if you have an employee manual. But Jose, you want to start with an employee manual, why it's important to have? And
Sure. I mean, look, the downside of having an employee manual is that you now must follow it, right? So you have to make sure that you know exactly what the rules are. But my opinion is more, if you lay it out, no employee can come back to you and say, well, I didn't know. Yes, you did know from day one. You had to sign off on this and acknowledge that you read the policy and that you understand. So, one of the major components of our handbook is basically, the equal employment opportunity laws and harassment. There's certain procedures that you should have in place, right? So you don't want an employee bothering the supervisor on an issue or bothering someone else about an issue, talking about it. You want them to know, who do I have to go to report some type of violation? What's a formal complaint? What form do I have to fill out? Everything's mechanical, so you don't really have to use your judgment at that time. That's very important also to know about what are the leave policies? What are the working hours? What are your employee benefits? What are you entitled to? And also I bring back the remote employees, because how do you track the time for these employees? How do you make sure that, if an employee doesn't go into overtime, that they need prior approval for that, if you require that, right? So you have everything laid out in the policy. You need to also lay down, be up to date with the laws that come out. And one new one that I'll raise, which is an interesting issue, is medical marijuana and recreational marijuana. Just because it passed, in New Jersey, doesn't mean you can show up to the office high, right? I mean, it's just you can't. So you can have a strict drug and alcohol policy, but you want to incorporate something on the marijuana use, because a recent case held that the law against discrimination, if it's a medical marijuana use, you have to provide the employee, if they requested, an accommodation, right? So say I don't have an employment manual, right? How do I know I have to ask formally, and who do I ask formally for an accommodation, right? So that's another benefit of this manual. Pretty much all the rules are set out in this manual. But just I thought this case was pretty interesting, because the problem with that employee is that they tested positive, but for some reason the test can be false, because it could have been in their body 2 or 3 days before, and the employer didn't really provide an accommodation for this employee. So something to be careful about.
Yeah, interesting that you brought up the cannabis thing, because I was going to cover it too. But a lot of our members, unless they have a federal contract, they don't even sample or test for cannabis. But get used to this following acronym. It's called WIRE, and it's a workplace impairment recognition expert.
Right.
And so the Cannabis Regulatory Commission is going to propose guidelines. So the theory here is that everybody, every employer would need to have a WIRE on staff, or hire somebody that's a WIRE that could recognize when there's an impairment with cannabis. Because to Jose's point, you got the medical side of it, but now that it's legal, it's just like alcohol, right? So if somebody comes in and they're impaired with alcohol or opioids or cannabis, you could tell them to go home. But yeah, it's a good point, Jose. But getting back to the,
I just want to make a point about cannabis, because just like you said, Tony, with alcohol, it's and Jose, absolutely, like you should have whatever your drug and alcohol policy is. It needs to take into account that cannabis is now legal, right? Cannabis use, but it really comes down to, can the employee do the job, right? Are they able to still function at work? Because if they're able to function at work and not be disruptive, so what if they have cannabis in their system? Who cares, right? But if it's impairing their ability to do their job and to interact with their employees, then we've got a problem. And that's when you need to bring in one of these WIRE people to who can who can test, but of course, we don't have rules about that yet. So,
Yeah, hold on. I think there was a question. Does there have to be an accommodation for medical marijuana for drivers?
oof,
Good
that's a
question.
good question. Yeah.
That's tough, right? I mean, that's their main job is to drive. There
Yeah.
may not be a reasonable accommodation. So the answer may be no. I mean, facts and circumstances maybe put them in a position where they're not driving, but in terms of actual driving, I don't see a way around providing some reasonable accommodation
Yeah.
to that
Yeah.
situation. Yeah.
I
Yeah.
agree. Like when you're talking about safety sensitive positions like drivers, like operators of heavy mechanical equipment, or, it's a federal, it's a job under a federal contract where cannabis is still illegal, then you can't make an exception for that. Then you can't make an accommodation for it. But, but what if the driver's not, marijuana's in his system or her system, but they're not impaired? They're, that's a whole, that's a conundrum.
Yeah, interesting. I guess, Gail, I could actually follow up with the Cannabis Commission and see what they say about that too. So,
Yeah.
or even the
Thank
industry
you.
folks. So before we go on, Jose, I got a question about do insurance companies, in order to get professional liability insurance, do they require that employee manuals exist? I don't know if there's like a mandate from an insurance perspective.
I haven't seen that. Look, I know the insurance companies, like on the cybersecurity front, they require you to have an exhaustive amount of things for them to insure you because they've been getting hit hard. But from an EPLI standpoint, I have not really seen a mandate on that from carrier perspectives.
And then I appreciate that. And then the other thing, and then we can get into the Secure Act, Jose. But so it's been a while since the Pay Equity Act was signed, into law here in New Jersey. And this is going back to like 2018, and I could check with the labor commissioner, but I remember, and I've been at seminars and discussions with members. Again, I'm surprised, forget about not having employee manuals. A lot of people or employers don't have good job descriptions that they should have on file, because if they're ever challenged on a pay equity issue, the first thing that's got to be pulled is, well, are the job descriptions there? And are the jobs comparable? So just a reminder to have good job descriptions on file.
Mhm.
But Jose,
That actually also serves employers well when it comes to accommodations, because then you see here, this is what you're supposed to be able to do in your job. And if you can't do it with or without a reasonable accommodation, well, then, we have to let you go.
right.
So, yeah.
Thanks.
Pay equity, you should also do, if you do a study, because if the DOL comes out and audits you, it may or may not be privileged. And so you have to be careful, make sure you have, even if you haven't, say, a consultant doing the actual study, you make sure that they're doing it under the direction of an attorney so that you can preserve the privilege from the beginning, so that the attorney can then make a legal conclusion as to what they found. And then you can protect the privilege as much as that's the best that you can do. It doesn't even, guarantee that the study will be privileged vis-a-vis the government if they come in and do an audit.
So here's a question: should job descriptions include physical requirements of the jobs? I don't see why not.
Absolutely.
Right.
Yeah.
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 Okay, Jose.
Jose,
I'm
you
sorry.
raised a good point about, confidentiality of, when you have someone coming in to look at pay equity. And I agree. And also when you're doing internal workplace investigations, if it's under the direction of an attorney, the investigator doesn't, necessarily, and shouldn't be actually your regular attorney, because then they can't defend you because they're a witness. But if it's under the direction of your regular counsel, then there's a chance it could be privileged. Then again, you may want to use it in litigation because it could be helpful. So
I will put it in the engagement letter, very easy. We are hired here to conduct this investigation under, the auspices of, Alex Rubin, for her to make her legal conclusion upon finishing my investigation.
All right, Jose, we got about 10 minutes left. Anything on Secure Act and 401ks? Yeah.
So Secure Act 2.0 got passed in December 27th of last year. It's of course, there was Secure Act in 2019 that passed, and basically these are just I want everybody to, because as a fiduciary of a plan, you have a lot of duties surrounding that. This is not, something that's going to create litigation. This is more enhancements, right? These are things that will help folks and increase their retirement system. So I'm going to point out several things. I have an outline, and the outline is about 100 pages. So that's how much legislation was passed on retirement plans. But I'm going to focus on 401k plans only. And again, this is just the surface, right? So in New Jersey, I think it's this year, you're either required to have join the state's retirement plan or offer a 401k plan to your employees, some type of retirement plan. So for new 401k plans, you're required to automatically enroll all your employees once they become eligible. So that means, they become eligible in the plan, they can elect to come out of the plan, but from the start, they have to go into the plan. And on top of that, you have to deduct 1%, between 3% and 10% of automatically enrollment with an increase of 1% per year. So you take out the first year 3%, next year 4%, 5%. I don't think I put away 10%, but yeah, it goes all the way up to 10%. So this allows employees to put in money. And, at the end of the day, this has increased participation nationwide, these automatic enrollments. It's just because people don't realize that how much it's not really costing them that much. It's tax-free money that's going out. So it really helps in that regard. There's another thing, so improving coverage for part-time workers. So the Secure Act said that if an employee is a part-time, and this is long-term part-timers, right? So if a part-timer did 500 hours this year, 500 hours next year, 500 hours the following year, in 3 years, you must make them eligible to participate in your plan. Well, the Secure Act 2.0 lowers that requirement to just 2 years. So if you have part-timers that work 500 hours in 2 consecutive years, then you have to allow them to join the plan. There's an increase for, the mandatory distributions. Before they increased it from 70.5 to 72. Now it's up to 75. So higher catch-up contributions. So catch-up contributions are basically allowing folks who may have not put away for retirement at earlier years, if you're over 50 years old, you're able to put in more money beyond the limits that a normal employee would put in. Well, now they're even increasing that for folks that are between the ages of 60 and 63 to be able to put in even more money into their retirement. There's some withdrawals. So withdrawals, you can't withdraw from the plan without getting penalized, right? Because it's tax-free money. So they're allowed for some distributions for emergency expenses. So $1,000, not to exceed $1,000. There's another one for domestic violence survivors for them to get a distribution of $10,000 or 50% of their account balance. And then the other one is if you're in a location where there's been declared a disaster, you may be able to receive distributions up to $20,000. This one, you'll like this one. So if you have a student loan payment, and you're paying back, your employees are paying back their student loans, you can treat that as an employee deferral for matching purposes, right? So even if they're not in the plan, you can say, okay, so I'm paying my student loan, say $100 a month of my student loan. So you can add in the retirement plan as a match to those payments for that participant. So the law allows you to do that. So that was a little creative, I think. From the legislatures. The other one, allowing you to get a distribution to pay for long-term care insurance, and also allowing for small financial incentives like to join the plan, like giving them a gift card of $25 gift card. If you join the plan, you're allowed to do that now as well. And then lastly, I just want to touch on some corrections. If there's an overpayment, this typically happens. Sometimes you may have an overpayment of funds. The fiduciary is not required to go recoup those funds. As before, you had a duty to recoup. Depending on the amount involved, they're being more relaxed on this, whether you have to recoup those funds or not. And lastly, and which you should always be doing, is reviewing your plan for errors. So the IRS has this voluntary correction program, whether you can self-correct, and then if there's certain more egregious violations, you have to file with the IRS voluntarily and pay a fee, and then it can get even more, all these other fees. Well, they're expanding the self-correction component, which is great because nobody wants to deal with the IRS. I can correct it. I'm following the IRS's rules, right? And my plan is compliant now, and I don't have to see the IRS. So everybody's happy. So I think that's a win-win. You'll see some regulations on that in the near future.
Good stuff, Jose. Here we are butting up against 10 o'clock. Anything that anybody wants to bring up that we
Actually,
didn't cover?
I had a question for Jose.
Yeah.
You mentioned something about now it's mandatory for employers to provide some type of retirement plan to their employees. Is that just for employers of a certain number of employees?
I believe so, but the threshold is very low the last time I checked. And I think this year, and I think it's actually delayed because the state has to have the system up and running, and they haven't. So I checked the website maybe a couple of weeks ago, and it's not up and running yet. But yeah, so the option is join the employees can join the state fund or offer their own retirement plan.
But there is a number of employees threshold.
I believe so, but it's a very low threshold.
Okay, what is it, like 10 or 15 or 20?
Maybe. I'll have to double check.
Okay, I'm just curious what that is. Okay, thank you.
All right, I was going to be quick about the legislative side of things. I mean, fortunately, we've been kind of quiet. The only thing that's really been bubbling up on the labor side is there's big focus on temporary workers. So if you guys own buildings or clients that own buildings, there's a concern out there that when there's new ownership, that I guess they're focused on cleaning services, janitors, cafeteria workers, that they want some sort of retention if there's a change in ownership, meaning that you can't lay anybody off for like 90 days. That's a bill that's going through. It hasn't gone final yet. If the governor did sign on February 6th, the Temporary Workers Bill of Rights, if you will, and that really targets staffing agencies where, again, there's like requirements in the law now that, they have to provide transportation to the job. They have to do a detailed pay stub, those kind of things, because apparently there was some concerns that, people working for temp agencies, really didn't get the same kind of rights. But again, it's been kind of quiet in terms of new initiatives. And again, we've talked about this last year. Just keep an eye on your 1099s, the wage and hour issues. I know that the labor department here in New Jersey still going out doing audits. So just kind of keep that in the back of your mind as we go.
I want to just really quick add to what you're saying with the temporary staffing. I'm on the board for the New Jersey Staffing Alliance. And part of that bill and that now law is that the temporary worker has to make the same amount as the permanent worker. So now as a staffing agency, where do you make your money if that's the case, number one? And number two, the staffing agency then has to go to their client and find out how much the permanent worker is making, just so they can pay the temporary worker that same amount, which, as we know, would probably not going to happen. So we've actually written many letters to the senators and even a lot of staffing clients who have clients have went to some of their larger clients, and their larger clients say, if that's the case, we may move out in New Jersey. So
really?
It may have a negative effect on larger companies.
Yeah, you know what, Fred? I was talking to a couple of accountants that sit on the Staffing Alliance board as well. So maybe we can, circle back on it. Because look, we could always. It's not easy. I guess he just signed it last month, so we'll see what happens. But the good news in terms of Trenton is it's all about the state budget right now. We're scheduled to testify on the budget next week, but they'll take the better part of the spring through the end of June. So why is that important? Because once we get through the budget, they'll take the summer off probably, and then they'll take the fall to run for election. So that means that if they're not in Trenton, bad things don't happen, right? So the window here is short, but we'll stay vigilant on things in Trenton. So again, did anybody have an issue that, again, from an HR perspective, that we haven't touched on today? If not, George, as our sponsor, you want to say hello to everybody and tell us about TAC?
Oh, thank you, Tony. And first, I offer my compliments to the speakers. Great job, very thorough, and I very much appreciate getting the update. We have a labor practice as part of our firm, although our claim to fame is environmental land use, development and redevelopment. We're located in Robbinsville, just outside of Trenton. And I've known Tony for many years, and Tony, my compliments as always. Great program. Thanks very much. And it was a pleasure to be here today and sponsor.
Thank you, George, and Alex, Jose, and Fred, and all of you for joining us today. Again, this was recorded. We could send it out. I want to thank Kathy, Julia, and Taurine. If the three of them could stay on afterwards, I got some other stuff to go over. But thank you, everybody. Stay safe, and we'll see you at the fashion show at March 21st at American
Tony.
Dream.
All right.